Hello and welcome back to the Idaho Legal Aid Services web series on evictions in Idaho for non-payment of rent. In this part, we're going to be talking about Idaho law and what it specifically says about the eviction process when someone gets behind on their rent and what landlords have to do in order to be able to evict someone. So the applicable law here is Idaho Code 6-303, and it talks about unlawful detainer in Idaho. You can consider the term unlawful detainer to mean eviction when you read it. And so we are in part 2 of that statute, and that's what talks about the process that the landlord has to follow to evict someone for not paying their rent. Non-payment of rent essentially means that for whatever reason, the tenant hasn't paid their full rent during a given month, or that the landlord hasn't received the full rent. And it's important to note that this statute can apply to both verbal and written leases. So you don't have to have a written lease to be evicted for not paying your rent. So the statute requires that a landlord provide a 3-day notice to pay or quit to the tenant to start the process. What that means is that a landlord has to give them a piece of paper saying that the tenant has to pay the rent that's due within 3 days or leave the property within 3 days. That's what quit means. It's important to note that the notice must be written. It cannot be just a text message, just an email or a phone call. It has to be a written piece of paper. And the notice also must state the correct amount of rent due. This is really important because if it doesn't state the correct amount of rent due, that could be a defense if this case comes before a judge at a later time. Now, when you receive the 3-day notice, it has to be done in a specific way under Idaho Code 6-304. And so your landlord must give you the notice either by personally delivering it to you, or by either leaving it at the rental property with someone of suitable age, or posting it to a noticeable place on the rental property, and mailing a copy. If the landlord uses either of these two second options, they must also mail a copy to you. So how do we calculate the 3 days under the 3-day notice? This is under Idaho Rule of Civil Procedure 2.2, and the day that you actually receive the notice is considered to be day 0, with the next day being day 1. So, for example, if you received a notice on Monday, Tuesday would be day 1, Wednesday would be day 2, Thursday would be day 3, and the landlord would be able to file an eviction case on Friday. So you would have through Thursday to pay the rent if you received the notice on a Monday. Now, you will need to include holidays and weekends when counting the 3 days, unless the third day falls on a holiday or a weekend. So as an example of that, let's say you got your notice on a Friday. Saturday would be day 1, Sunday would be day 2, and Monday would be day 3. If Monday happened to be a holiday, then you would have until the following Tuesday to pay your rent in full. Now, what does a 3-day notice mean? A 3-day notice is the start of the eviction process under that code section, Idaho Code 6-303. It is not the same as a 30-day notice. If you have a lease that is going to be ending soon, or you have a month-to-month lease, either the landlord or the tenant can give a 30-day notice to end that landlord-tenant relationship. And that's not necessarily an eviction notice, and it's definitely not the same as a 3-day notice in this situation. A 3-day notice here is just saying, hey, there's a problem, you're behind on your rent, and it needs to be fixed within 3 days, otherwise I'm going to take other action. Now, a 3-day notice alone does not mean you have been evicted. It is, again, notice of a problem that needs to be fixed. And it's important to note that the 3-day notice alone is not public record. If you get one, that doesn't mean anyone else has received it. It doesn't need to be notarized or anything like that. It could wind up filed with the court later if the landlord does go ahead with an eviction process. But getting a 3-day notice alone is not something that's going to show on a permanent record anywhere.